Our weekly immigration news roundup is brought to you by the law firm of Figueroa & Associates. For consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.
Hello, my name is Mary Campbell, legal assistant at the law firm of Figueroa & Associates, and your presenter with this week's immigration news. U.S. reverses key child protections for green card applicants. What immigrant families need to know. The U.S. Citizenship and Immigration Services, USCIS, has rolled back a crucial policy safeguard that had protected the green card eligibility of children of certain temporary visa holders. Effective August 15, 2025, the agency has changed how it determines a child's so-called CSPA age, eliminating the use of the earlier dates for filing chart and relying instead on the more restrictive final action dates from the Department of State's Visa Bulletin. Background: the CSPA and the 2023 policy change. The Child Status Protection Act, CSPA, enacted in 2002, was designed to prevent children from aging out, losing derivative eligibility for a green card when they turn 21 due to lengthy processing delays. Under the CSPA, a calculation subtracts the time a petition was pending from the child's age at the time a visa becomes available. In February 2023, the Biden administration enacted a policy shift. It allowed children to lock in their age based on the filing date, using the dates for filing chart instead of the final action dates chart. This provided vital breathing room for many families facing red tape and visa backlogs. Reversal in 2025. Under the Trump administration, USCIS announced on August 8, 2025, that it would discard the February 2023 policy for new applicants. Henceforth, the calculation of a child's CSPA age will depend exclusively on the final action dates chart. Effective August 15, 2025. For all new adjustment of status applications, those already pending before the cutoff date retained the earlier, more favorable protections. The agency cited a need to ensure consistency between how applications are treated domestically by USCIS versus abroad at the State Department, noting that the 2023 change created disparities in treatment. Who's impacted? Children of H-1B visa holders, many from India and China, where green card backlogs are notorious, are particularly vulnerable under this reversal. Estimates suggest more than 200,000 youth could lose protected status as soon as they turn 21, suddenly finding themselves ineligible, even if they've lived in the U.S. nearly all their lives. Advocacy groups highlight the severity of the setback for documented dreamers. They emphasized that the change underscores the urgent need for congressional action to create lasting bipartisan reform. What immigrant families should do. Families with children who are nearing age 21 or are already approaching it should act swiftly. Those with adjustment of status applications filed prior to August 15, 2025 will remain under the more favorable February 2023 rule. However, children whose parents filed on or after that date will now be subject to the final action dates rule, narrowing their window to qualify. Families may need to explore alternate immigration remedies or seek legal guidance to preserve eligibility.
Our weekly immigration news roundup is brought to you by the law firm of Figueroa & Associates. For consultation on any immigration or legal matter, please call 855-768-8845. That's 855-768-8845. For full stories and more immigration news, visit www.theimmigrantsjournal.com. That's www.theimmigrantsjournal.com.